everybody, excited utterance here. My name is Hella. This is Suni. She's been causing all sorts of trouble and pressing buttons, space bars, and chasing mouses around. Indeed. And if you're wondering where Seraph is kind of annoyed. Hang on a minute. Kind of annoyed, sitting in the other room going, I'm sick of this kitten. I've had about enough of her. Yesterday, Seraph was asleep, and Suni just decided to camp out on top of him, There was a few swats at her, and she just wouldn't give up. She was just like, nah, I find you comfortable. And so Suni fell asleep on top of Seraph, and Seraph was like, fine. And I do have photos of this. I will post it on the Discord. Guys, if you're not a member, there's reasons. Get onto the Discord for multiple Suni photos of her really, really annoying both my cat and my giant dog. And now we have more emojis. Check them out. They're pinned to the top of the chat. We now have Suni emoji. We have justice. Justice for Sarah Boone. Justice for everybody. And we have, what else we got? Oh, we have a Dr. Pepper emoji. And what else we got? We have Sarah jumping out of a suitcase, because why not? Yeah, we are just so many emojis. Everybody needs to enjoy the emojis. Please become a member. It really helps the channel. Myself and Dali. Thank you to everyone who's new. Good to see you. Thank you, Cat Not Williams, earlier for rating Dali. That was lovely of you. Right, let's get into it. So, Mavka, bogging with Boone. Indeed. Hello, Laura. Hey, Kat. Hey, everybody. Now, here's the thing. You know how I feel about Sarah Boone. And people conflate the issue here. They think that I like Sarah Boone, or I think that she's not guilty. That's not the case at all. And I get into a few, internet arguments with people about this. Not the case at all. I'm someone who's very, very defense biased. I feel like I know that everyone is entitled to a fair trial. And I feel like this lady down here with MS Clippy looking at her boobies has been very much hung out to dry by the media, and a lot of misinformation has gotten around about her. She's not the most likable person. She's pretty annoying. I get that. And she did kind of sit there whilst her boyfriend was in a suitcase, whilst he was going, Sarah, I can't breathe, honey. And then she fell asleep. It's not the best set of facts. I get that, right? But even without the best set of facts, even if you've done something very, very terrible, you're still entitled to a fair trial. And I do feel like a lot of the things that we've been told about Sarah Boone and her behavior over the last 4 years are just not true. And regardless, even if they are true, she's still entitled to a fair trial. One of the things we've been told is that she has burnt through 8 lawyers, or even that she sacked 8 lawyers. Neither of those things are true. She hasn't sacked lawyers at all. They've recused themselves. And there hasn't been 8. There's been 4. Because the other lawyers, they had conflicts of interest. As soon as they were appointed, because they were public defenders, as soon as they were appointed, they came along and they said, hey, I can't actually represent this lady because I have an ethical conflict of interest, meaning that I know somebody involved with the case. So I think 2 of them defended George, her boyfriend, the one who's actually the decedent in this instance, and therefore could not be involved in the case. One of them knew a witness. And this is really normal procedure. If a lawyer knows somebody involved in the case, they just can't be involved in it. So that's one thing. So people keep going on about the fact that she's been through these 8 lawyers and she abused them. Now, when you think about a criminal defendant abusing a lawyer, you think about them like being physically abusive, like spitting on them and stuff like that. She didn't do that. what she did was she wrote them letters. She asked for their assistance. One of them, I think his name was Bankowitz. He was the most incompetent of all of the lawyers. He stuck with her for a year, and I think he had like 3 meetings with her the entire time. He went MIA, basically. And I've got to tell you, she called him a dud and a buffoon. That was the worst thing she said about him. And I've got to tell you, he really was a dud and a buffoon. He kind of deserved it. So the things that she's done, she's been annoying. I'll tell you that. She's been annoying, but she deserves a fair trial. Now, the most recent thing that's happened is that the judge came along and said, you know what, this has been going on for way too long, and you've waived your right to a public defender. You're going to go pro se, which means that you're going to defend yourself. You're going to defend yourself. Okay, great, fine. And so she was off there defending herself, and she was doing an okay job of it until someone just this last week came along from Northern Florida, because she's down in the South, Northern Florida, and his name's James Owens. And I'm going to show you him now. So James Owens came along and said, you know what? I think I can help this lady. Now, here's James Owens, and I'm going to show you a little clip of him before we look at the hearing today. And I really had a lot of hope for him. I'm a little bit disappointed by some of the things he said. This is an interview that he did just after the hearing today. It's a little interview, and he's speaking to this Fox 35 Orlando. By the way, they spread a lot of garbage as well. And he's repeating some of the stuff that have been getting around in the mainstream media. You think he would have checked the documents, because we've been on this channel checking the documents, and we've been trying to spread around the fact that, hey, there's not been 8 lawyers, guys. There's been 4, amongst other things. And he has gone and said that there were 8 lawyers. Yeah. More dog on stream. Mate, if I brought my dog in here, she would destroy everything. She is a German Shepherd. She's massive, and she's rambunctious. Dali's here.
Hey.
Hey. Have you seen this interview with James Owens? No.
Mm-hmm.
I was just going to say it first, because I think it'll give some good context as to why he's even there, for one thing. Yep. And because people are also talking about what on earth. Oh, hey, beautiful waterfall.
Whoa.
George's brother. Yes, that's another thing that's happened. So George's brother, who is the victim in this case,
wow.
His brother Farrell killed his girlfriend in May. And guess what? He is in jail right now on 2nd-degree murder charges.
I'm not laughing at that.
It's just spooky. The 2nd-degree murder charges.
And obviously it is not relevant at all to Sarah's case, but the fact that she's arguing spousal abuse or domestic abuse as a defense, that's creepy.
Look, people are sort of sainting George, like they're kind of going on and making out like George is some kind of innocent party in all of this. There is no way that there was not abuse on both sides, both parties. And to say that George didn't do anything at all in lead up to this is just silly. But that said, it doesn't mean that he deserved to be put into a suitcase and allowed to just suffocate to death whilst he begged for his life. So there you go. All right. So, well, he won't be sitting behind the DA's table. No. All right. So anyway, I just wanted to play you this. So Sarah Boone's new lawyer discussed a possible plea deal with Florida prosecutors. Look, I'm sure he has been discussing a possible plea deal. There's been plea deals discussed all along. Doesn't mean she's going to take one. But let's just listen to this James fella having a chat to Fox 35 Orlando after the hearing today, and then we'll go and have a look at the hearing, because the hearing is really interesting. All right, so Oops.
Thank you.
I am
Excuse me?
going to have to bring this sound up for you. Just a minute.
Yeah, this is the press interview, I believe. That. Okay.
Sarah Boone needed a lawyer.
Hang on. Well,
I mean, I can't imagine our system. The case is an aberration. Okay, this just a gap in the system that hardly ever happens.
He's not wrong.
On the federal level, on the state level, everybody charged with a crime is entitled to counsel.
can you hear that at all?
Everybody.
I can a little bit, but it's really quiet.
The client,
You can send me the
defendant
link and I can
waives
try
their
if you have
right
trouble.
and wants to represent themselves, which is rare and foolish.
I've got just about everything going on here. Hang on just a minute. Yeah, I'll leave it to you.
Okay. Sorry, guys.
Sorry about that, guys.
Okay, 1 second. I'll pull it up.
You do that whilst Dali's doing that. I'm just going to read you the
But I
article.
understand the judge's ruling. We respect the judge's ruling.
Okay. So Sarah Boone's new lawyer said he spoke with Florida prosecutors about a possible plea deal ahead of her upcoming trial. James Owens, who was based out of Milton in Florida Panhandle, recently agreed to represent Boone. Sarah Boone needed a lawyer, Owens told reporters outside court today. He said he saw Boone's self-drawn advertisement. For those who hadn't seen it, hang on, let's bring it up. There it is.
All new at 6.
Oh, come on. No, forget it. Okay. Boone is facing a second-degree murder charge in the 2020 death of her boyfriend, Jorge Torres Jr. in their Winter Park apartment. Torres Jr. was found unresponsive and locked inside a suitcase. According to the arrest affidavit, Boone told police the two were drinking and playing a game of hide and seek. She has pleaded not guilty to the charge. We did make attempts, like everybody does in every case. Any prosecutor, any criminal defense lawyer, public defender, you have plea negotiations. That's just part of it. So there were attempts to settle, Owens said. I was kind of like a mediator. I was kind of like a go-between because once she became pro se, it's very difficult for the prosecutor to then communicate with the defendant. Right. As you can imagine, not having someone to negotiate for you, and she's trying to negotiate with a prosecutor who's trying to send her to prison for the rest of her life, somebody had to do it. I was doing it, he said. At the time, Owens had not officially signed on to represent Boone. However, after a couple of weeks, a few meetings with Boone, including a phone call with her, he decided to take on the case. During Tuesday's hearing, that's the one we're about to look at, Owens asked to delay the trial a few months to the end of the year or early next year. Florida Judge Michael Craney denied that motion, citing the court's previous ruling that Boone's October 7 trial specially set and would not be delayed for any reason, including if she retained a new lawyer. Okay. And we will look at the rest of this in the video. You got it ready to go?
I believe so.
Okay, let's go.
Thank you.
Is that too loud?
No, go.
Okay.
Sarah
I can still
Boone
barely
needed a
hear it.
lawyer. I mean, I can't imagine.
Now?
Our
No, it's quiet, but play it.
Okay.
system, the case is an aberration. Okay, this just a gap in the system that hardly ever happens. You know, at the federal level, on the state
Sorry,
level,
guys. You're just going to have to turn the sound up and we'll then be quiet when we come back in.
Everybody, never, unless the client, unless the defendant waives their right and wants to represent themselves, which is rare and foolish. But I understand the judge's ruling. We respect the judge's ruling. But that left Sarah in a position where she's standing in a courtroom accused of murder without a lawyer. I can't think of any other time that you would need one than in that scenario. So once that decision was made by the court, Sarah put an ad out. Somehow it got on court TV. I watch a lot of YouTube true crime.
Couldn't imagine how.
I didn't immediately act on it. I waited 3 or 4 weeks thinking that one of the members of the defense bar here in Orlando would pick up the torch. 3 or 4 weeks went by. It did not happen. I had another case down here in Hillsborough County in Tampa that I had to come down for. So I wrote her a letter about a week before that, and she had a third party, a girl from Minnesota, that reached out to me. I think first just to see if I was legitimate. They said to see if I was, I think catfishing is what they thought I was doing, somehow, some fraud. I think once the third party realized that I was genuine, then Sarah called me. And we talked on the phone a couple of times, and I said, hey, I'm coming down that Wednesday for that court case in Tampa. Why don't I just come down Monday, which I did. I got done with court, I think, Monday at noon. I drove down 6 hours, spent the night, got up the next morning. I think that was on the 20th. And I spent about 4 hours with Sarah Boone at the Orange County Jail. During that period of time, I was in talks with the prosecutor, let him know what I was doing. He wanted me to file a notice of appearance. I wasn't ready to make that commitment yet. Didn't do that, but I got Sarah to sign a document essentially saying, you know, you can speak to the prosecutor on my behalf. There was attempts to try to resolve it. If we would have come to terms, I would have filed the notice of appearance. We would have set it for court.
Hang on. This is not the one that was on. Did you go to a different link?
No.
Okay.
No, it's 11 minutes, I think.
Oh, okay. Well, 11 minutes. Mine was not 11 minutes.
There is a video that's like 2 minutes at the top, but this is the one you started playing.
Ah, check it. Okay, cool. All right. No, I don't need to watch the whole thing. So
No?
I want to get to the part where he talks about how he's being retained by her. So can we flip forward a little bit?
Sure. Can I just say that this guy thinking like another, whoops, sorry, I replied as you, but this guy coming in thinking another lawyer would step up and do the right thing and help Sarah out, and nobody did. And he just kept it in the back of his mind and was like, God damn it. Somebody has to help her.
Yeah.
And he now is stuck in a really, really, really unenviable position in so many levels. And so he's going to have a lot of expenses on his end.
Yes.
And he's stepping up, and doesn't seem like he's doing it for fame, actually.
I got to give it to this dude. Like, and this is what I've been saying all along. Why is no one doing this? Like, this seems to me to be the right thing to do. And then, like, all of the haters out there have just been going, I can't believe, why would anyone want to represent her? She's so this, she's so that. And it's like, it's the right thing. She deserves a fair trial. I also can't believe that the judge has just allowed all of these defense attorneys to just walk so quickly. There's been no real reason. And she, Sarah Boone, has not been like, oh, I can't work with them. There's only been one. Yeah. And that was Bankowitz, that she said, yes, allow him to recuse himself, please. And he was useless. Yeah. Bankowitz was useless. The others, she was fine. She just wanted to keep going. I don't suppose we're able to just click forward, are we?
Sure.
We can. I want to hear the part about him being retained, because she owes him.
Yeah.
Everybody does in every case. Any prosecutor. So there were attempts to settle it. I was kind of like a mediator. You know, I was kind of like a go-between, because once she became
I mean, it sounds like it's going to be really interesting. There's 8 minutes left. I don't know if you want to watch it all, but at least we can skip if it gets boring.
Say, it's very difficult for the prosecutor to then communicate with the defendant. Actually, the rules say you got to do it on the record. And you can imagine not having somebody to negotiate for you, and she's trying to negotiate with the prosecutor, trying to send her to prison for the rest of her life. So somebody had to do it. I was doing it. But after those, so I met with her that day. I went over to Tampa, handled my case. I think I was done at 2:30. I came back. Well, Billy Lane, the investigator that's assisting Sarah Boone, pro se, he had scheduled an appointment to meet with Sarah that night. So I went back over to the jail. They let me meet with him. So the three of us met. This was, I think, the 21st. From 7 to 8:30, we met for about an hour and a half. And, at that point, we couldn't reach an agreement. And then I wasn't ready to represent her at that point. I immediately told the prosecutor that there was an impasse, there was no agreement, that I was not going to be representing her. I got in the car and drove back home, got home about 4. I had court the next morning at 8:30. I was done with the case. I did the best I could. I want to say 2 nights later, my wife and I were home and Sarah called and we talked again. Of course, I was still thinking about it, what to do. And, but I told Sarah I was not committed to doing it. That was on like the 23rd. Well, then that third party called a day or 2 later, and really nice lady that I really respect. We developed a relationship, and she asked me if I would go one more time. So I flew back.
I don't know who this person is.
We met again a couple of times. I can't remember the dates now, 25th and the 26th. But both meetings went well. And you got to understand, Sarah's been through 8 lawyers, so there's some trust issues.
No, 4.
Well,
get it right.
Yeah, I mean, yes, technically, but even
no.
Regardless, even 5 or 4, she's got trust issues.
He needs to get his facts right. This is terrible misinformation that's out there. This stuff is so bad for her public.
Yeah,
her public profile. He's her lawyer, right? Get it right.
Yeah.
There has not been 8. Keep going, because he's going to say something else.
On both sides, I'm concerned. Is she going to try to fire me, or we're going to have problems the same way?
That too. She didn't fire anyone.
Yeah.
See, this bothers me.
Yeah, I like the guy a lot so far, but that part he shouldn't have aired publicly. He shouldn't have.
Just get your facts right. That's all.
Yeah, and he shouldn't. I don't like that he's airing some kind of negativity about Sarah.
Yeah,
but I mean, he is so far stepping up, and
he is.
Imagine, but I like her. She likes me. We communicate well. I think we're both on the same page, and I spoke to my family, my wife, my daughter Sarah about it. Sarah's.
Oh, she got a daughter for Sarah.
Okay, that's a little freaky.
Nah, not really. Like, it's a pretty common.
Oh, that okay? Yeah, you're right. Yeah, everybody's name's Sarah.
Yeah, I know like 20 Sarahs.
Some colleagues that I practice law with, a law group. They're in Milton. And obviously, it's going to take some staff to pull something like this off, especially knowing that the judge, I was in hopes he was going to continue it and give me 2 or 3 months. He did not. So we've got about 30 days. So I'm going to have some help from the staff. But we're trying to assemble a team right now. I've got a couple of friends that are lawyers that have indicated they're going to help me.
Wow.
And what are friends for?
Are you doing it pro bono?
I've been retained.
This bit.
I'm not doing it pro bono.
Who's paying for it?
Sarah owes me.
Owes you what?
A little more to your plan for defense about the battered spouse syndrome.
Well, I'm not an expert, but I don't know if we're going to be able to do that because we're time crunched now. As you know, I think y'all understand the rule now. We've only got till the 9th, which was today, the 3rd. We've got 6 days.
What's the whole chunk?
To pay for Dr. Julie Harper to fly down here later this week. She's actually from my area. The 2 experts that I had asked for, well, there's a third one, but 2 of them are from my area. Dr. Harper's from Okaloosa County and Dr. Berkman's from Escambia County. But
no.
With Dr. Harper, I think I'm going to get her to fly down here later this week to meet with Sarah several times. Hopefully, at the end of those meetings, like I said, she's already met with her, but it was 2 years ago. She met with her 5 or 6 times. Hopefully, she's going to agree with me that she does suffer from battered spouse syndrome. And so
Really?
if she's able to give me that opinion by the end of this week, my intent is to file the notice with the court and the clerk of our intent to rely on that defense. And then we go from there. That's really all I can say, Dr. Harper, not me.
So you've got 6 days to do that. Now, barring a Matlock miracle and that doesn't occur, what is your other, I guess, plan of action?
Oh, yeah, that's
Well,
perfect.
Sarah's been sitting in jail for a while. She's looking for her day in court, and we all want justice to be served. I'm a criminal defense lawyer. I've been doing it a long time. The state has the burden of proof. They have to prove their case. I know there's some strong evidence in the case, but there are some explanations. I'd rather not get into my other potential defenses, but we do have some defenses. They've got to convince the jury beyond a reasonable doubt. That's all I really want to say. Just like any other lawyer facing a trial on a criminal case, the state has the burden. We're going to test the state's evidence, and then we've got potentially a case to put on. But we'll see. We'll see what happens at the end of this week. It'll be interesting to see if we can utilize, because I do believe she meets the criteria just from everything that I have viewed in terms of Mr. Torres' prior arrest. I did want to say something else, but I want to say something, but I'll wait for you. If you
We
got
gotta
questions.
move downstairs.
Okay.
Or, I mean, we can just wrap it up.
We can just wrap it
What,
up.
you have to move over there if you want to say something.
The Torres brothers are violent towards women. I'll say that again. The Torres brothers, George and Farrell Torres, are violent towards their women. Farrell Torres is George's brother.
Here we
Are y'all
go.
aware of this? He was arrested in May in Seminole County for killing his girlfriend, the mother of his children. He stabbed her to death. I've got the file right here. He called 911. Eventually, the 911 operator got around to, where is the weapon? Where is the knife? It was still in her head. I don't know. Sarah's told me about the family, the dysfunction.
That won't be coming into the courtroom, no. It
So
won't,
no
old
doubt
line.
that's going to be admissible in my trial.
Yeah, well, yeah.
But there's two sides to every story. And Sarah's got a story.
He messed up earlier, I think, with speaking kind of negatively, but this is great move. Getting this out into the public.
Yeah, he has to get it into the public. It's not going
Right.
to come into the courtroom. No.
Unless Sarah testifies, but I don't know how.
Tell.
It's still.
Mistreated to some degree. It's difficult to represent yourself. I wish you could just imagine if you had a daughter that was in a situation where she's representing herself, or maybe a sister. Just for 10 minutes, just think about her situation. She's backed into a corner. And she's
Ooh,
the
he's
type
doing
of
good.
car, they're going to come out swinging. That's what she's been doing. Some of it is probably appropriate. Some of it has been inappropriate. But it's all she knew to do was to fight. And she's been fighting. She didn't have
Presentation. So he's an old school criminal defense lawyer.
Exactly. Now, guys, look.
Yeah.
That's his brother. That's George's brother.
I don't know how he identifies, but yikes.
What do we have to do to refresh, guys? Why do you want us to refresh? Are we all over the place?
What?
Everyone just says refresh and rewind. Did something go wrong with your playing of the thing? Do you
The whole
want to
stream froze?
Oh, I froze for a bit, or the whole channel was frozen? Okay.
Oh, okay. We'll play, I guess.
Play just the last little bit.
Thank you. 1-1. Oh, that's going to be admissible in my trial.
We're good now. Okay.
Okay.
Yeah, it was probably my fault. I don't know what it is with Wednesday mornings around here. Okay. It's Wednesday morning here. And yes, the ice cream truck man goes past and it's like he interrupts the whole internet void. He creates a vortex of internet. I don't know why. Anyway, yes, so that is him. That is George's brother. And his name is Farrell Torres.
Hmm.
And weirdly
Nobody-
enough, it's second degree.
I can see someone. I can see someone named Farrell doing this.
Yeah, no one named Farrell does anything good. Okay, so let's get into the hearing, shall we? Let's get into it. The whole channel was frozen. Well, you know.
Really? You missed my whole bit?
Really?
I'm the captain now.
Yeah, you missed all that. Seems fine now. Okay, good. All right, sweet. Let's get into it, guys. I had hopes that Judge Koenig was going to actually stop being a dick today. Yeah, but no, wasn't to be. So let's see.
We're just given a chance to undo the cluster F you did. And Sarah now has an appeal point because you didn't delay the trial for him. So that whole appeal point that you made her is still very much alive and well.
Very much.
You could have just covered your ass.
And you know what? He's doing this, I'm positive, because he doesn't know how to handle this much public pressure. Like, there is so much attention on him, and he will absolutely be flayed alive if he does anything that looks like he is giving any latitude to her.
Yeah.
And he said the dates, that was it. If he goes and gives a couple more months to her now, it will be seen as just giving her something.
Yeah.
And people will scream. And he's worried that his electorate, or whatever you call it over there, they're just going to hate him. And he's very popular. I've looked him up. He's very, very popular. When he was elected in 2020, he was elected 59 to 41 or something like that. And yeah, he cares more about the perception of him in this than whether or not she gets a fair trial. And I think that's what this is all about. I think he's worried about how he looks. But this is a real appellate point. Very clear. It'll be 5 years in February. Probably just wants this over. I'm sure he just wants this over, but it'll be much worse if it happens again. If he has an overturned conviction on his hands, that's going to look terrible for him.
Big time.
It's going to look terrible for him for the sake of a few months.
Yeah.
All right, let's go.
Oh, we get her cute little smile.
We do. And then look at people got so shitty about that smile.
I loved it. It was adorable.
Why is she smirking? Why is she smiling?
Well, she's obviously looking at somebody, and look at her. She's all nervous. Got butterflies in her tum-tum.
Judge, I'm James Owens, and I'm representing Sarah Boone.
Sir, good morning. Pleasure. Ms. Boone, good morning.
You might want to turn your sound down now, guys.
Raise your hand. Go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court on August 5. court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections
It's
thereafter.
reshuffled because she's not allowed
The
to
digital
say.
evidence review took place on August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in the court file. Mr. Cashore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense that was filed on August 14th. The next day, August 15th, JSCS filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that the JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I've tried to call him a couple of times, haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but
We remember her.
we don't need this neuropsychologist.
We're not answering her calls.
That Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I met with my client. I think my client meets the criteria for that spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I followed these judges yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motions. Yes.
Can I post them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to the hearing.
Thank you. The only thing I saw in the court file, counsel, when I was prepping last night was the motion for statement of particulars, it's called September 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have a motion for statement of particulars filed at 8:10 yesterday, but I do not have the motion for additional discovery filed 8:34.
I don't know why the court was not able to post that, because they were filed one right after the other.
One's in the court file, the other 3 aren't. They were all filed yesterday. not
Need a motion for additional discovery.
Certain things
Oh, hang on.
auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator, and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JCS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They are not here. Your motions for these various experts report that they were sent to all persons.
Okay, so I just want to address something. There was a motion that they were just referring to, this one here, motion for statement of particulars. Found this kind of amusing. This was filed on September 2nd by this new attorney. And it said basically that never in the charging documents was there ever a clear statement by the prosecutors as to what she actually did. So it said the pertinent part of the information states charges that Sarah Boone, on or about the 23rd day of February 2020, in said county and state, did in violation of Florida statute by an act imminently dangerous to another and evincing a depraved mind, regardless of human life, did kill Jorge Torres. But under Florida state standard jury instructions for criminal cases, 7.4 murder second degree section, Florida statute states to prove the crime of second degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, the victim is dead. Well, okay, sure. 2, the death was caused by a criminal act of defendant. And 3, there was an unlawful killing of victim by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. So the act definitions, an act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of events. So 1, a person of ordinary judgment would know is reasonably certain to kill or do seriously bodily injury to another. So we've talked about this. Would she have known that this act was reasonably certain to kill or do serious bodily injury to him? 2, is done with ill will, hatred, spite, or evil intent. Yeah, I think that fuck you for all you've done to me was probably enough. 3, is of a nature that the act itself indicates an indifference to human life. Not sure. So in order to convict of a second degree murder, it is not necessary for the state to prove that the defendant had an intent to cause death. So just popping down here to number 6, the rules require the information, so those original documents, like the charging documents, on which the defendant is to be tried, shall be a plain, concise, and definite written statement of the essential facts constituting the offence charged. 7, the information fails to inform the defendant of the particulars of the offence sufficiently to enable the defendant to prepare a defence. Wherefore, the defence would respectfully request the court consider this request and grant the defence motion for a statement of particulars. Okay, so this lawyer is asking them to please go back and look at the original documents and tell us where you have informed the defendant of the particulars of the offence sufficiently to enable the defendant to prepare a defence. Go right back to the beginning, guys, and tell us exactly where you have said, piece by piece, what the defendant has done in a plain... Go.
That would also go to, now he gets more information about what they're actually charging her with. He's not able to prepare until he gets that information. So that would kind of...
Now, beautiful waterfall. He's being very thorough. And in a way, yes, he is looking for loopholes, but you know why he's doing it? He's doing it to get time.
Yeah.
Right. So he's trying to buy time in order to get his continuance. That's all this
Clever.
is about. Right. He knows that they're going to be able to find something, either look into previous documents and go, hey, here it is, or that they can draft something up. Right. It's not that he doesn't think that they can find a way to do this. Of course. He's just clever enough to go, there's something missing there, and go find it, state.
Yeah.
And please, like, buy me at least some time to do that.
Yeah.
Maybe a week. I don't know. So yeah, clever. So that's what that's all about. I just found that kind of amusing. It's kind of
I liked it. Yeah.
It's been like 4 years and no one's thought of that.
No one's caught that.
Yeah.
I mean,
come on now.
On the service list through the e-portal, but I don't know how to address the reporting without having JCS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be
100%.
addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I have, I filed my notice of appearance on Friday,
Yes, sir.
and I've spoken with Dr. Brooklyn 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Brooklyn. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation.
What?
So,
Why?
I know time's of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the
State?
status of the provision of the autopsy photographs and the crime scene photographs and providing to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery.
Oh, his assistant.
Oh, my assistant. I told my assistant to do it.
Have that and not have to worry about getting.
She's
that
not a
from
paralegal.
I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB and we can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
If he wants to come back to my office, we can do it this morning.
Come back to my office.
Your office in the building?
Yes, it's in the courthouse.
Right there. Come up
Right
front.
there, let's go.
I don't have a USB.
Let's go look at
with me, but I'll
dead
find
people
one.
photos.
This morning.
Wait.
We'll get that done.
Okay, I appreciate you both. With regard to the motion for additional
happened?
discovery.
Sorry, I hit the wrong one.
Yesterday.
Yeah, you hit the wrong button.
2:34 a.m. State give the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars formally and in writing, given the lack of time we had to prepare to make a quick formal response.
Sure.
Oh, hello.
Counselor,
Hi
would you
there,
like in order
sis.
to file a
Aw.
response to the.
What a cute little
motion
smile.
For statement of particulars, and the, motion for additional discovery.
I would ask for at least a week.
That is a
Any
smile.
objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and motion for additional discovery no later than the close of business 5 p.m.
She's
on
smiling,
Tuesday.
I think so
September
too, yeah.
10th.
Yeah.
And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense, court's going to deny that as moot based on Mr. Owens' representation. with regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist. Stater, are you intending on filing a response to these?
No, we're gonna take no position.
She's 47
Okay,
in
I
October.
will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today, so that Ms. Barrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll
I
coordinate.
wonder if her birthday falls during the trial. What's it? Oh, hang on, let me look.
Oh,
up that.
10/10/77.
Oh,
Wow, I remembered that from earlier.
oh my God, her birthday could fall on her like verdict date. Oh no.
Is our girl gonna get a birthday wish?
Oh no. Imagine. That's like right at the end of the trial. Holy crap. Imagine.
Maybe the verdict's gonna be like one of those candles you blow out and then it reignites. And it's gonna be like, you're not guilty. Psych, you're guilty.
Psych. Psych.
Oh, I want her to be.
She's a jolly good fellow, for she's a jolly good fellow. Oh no.
Happy
birthday
birthday,
cake is
dear
like
inmate.
Nice.
Happy birthday, dear inmate.
Oh wow. It's in the first week of the trial. Oh, wouldn't it be funny if the jury all came in with a cake and stuff for her?
There's like birthday pats.
Yes,
stuff
birthday
on each
hat,
one.
a little badge. Oh dear, 40's alive.
I hope she gets some cake.
I hope they do something for her.
Right?
Oh,
God, I want her to be acquitted so bad.
Okay, here's the deal, right? She's not going to get acquitted, but just something like just brought down to manslaughter or something.
Well, I mean,
I want all of these people who hate her to just suffer. So
battered
bad.
spouse would be an acquittal, though, I think.
No, it's 1977. She's looking good.
Yeah.
Kind of. She'd be looking better if she hadn't been in jail for the last 4
That
years.
is true. I imagine the stress has certainly aged her.
Yeah. How do you clip kitten nails? Just don't. Just leave them. Just don't, because you can make them bleed.
Well, yeah, you can't do
Yeah.
it too far.
Hearing respectfully.
Judge, I'm going to want to add one other forensic
Yeah, I know, Joyce.
psychologist, make a request. I want to make sure that there's not an issue about
Yes.
my
Yeah.
client Sarah Boone.
Don't tell me you know.
manufacturing defense. And there is a second doctor, Dr. Michael Brandon. Spell that last name for me, sir. Dr. Michael Brandon. I don't know.
Barnen?
He spells it Brannon. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband, shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But
Got the
Dr.
Richard Patterson
Brandon
case.
testified that battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition,
Pause.
Dr. Brandon said victims of repeat violence may fear death.
What?
Sean was saying, and I think maybe Bronca spoke on it at one point, that her not opening the suitcase could be a self-defense thing. Maybe she tricked him in there if she felt she was in fear of her life. I mean, it's probably not going to work.
Yes.
But, I mean, if she opens it up and he is this violent guy,
yes,
she would be in danger. So,
but she's okay. But the problem is she said all this stuff that's really
yes.
She says
That's
some
why he's
stupid
trying to
stuff.
suppress the interview.
Oh, okay.
He's trying to suppress the interview.
What? To like the 3 people in the world who've never seen it.
Well, there's the interview, and then there's the interrogation video.
Yeah.
And maybe he can spin the interrogate. It's bad, or sorry, spin the video of her. But combined with what she said in the interrogation was really bad.
Yeah.
So if he can get that tossed out, then he can really spin up a good narrative, a better narrative.
Okay.
Play to the
Okay. I need to get, assuming they really are going to go with the battered spouse thing.
Well, they don't have an expert yet that will confirm it.
Yeah.
And they've got like 7 days to find an expert, diagnose it, and then file the paperwork.
Okay. Like, assuming this thing goes to trial, because I'm still not convinced it's going to go to trial. But assuming this thing goes to trial and they go with this defense, I need Andrew on this channel to talk about this. Because battered spouse is a self-defense argument.
Yeah.
It is. And I do not understand how they're going to do this. The only way, is with suppression of all of that stuff and to completely start with a whole new narrative of her being scared for her life. Because she said far too much stuff that contradicts that. She really does. And the video itself, like the actual video itself, contradicts that.
But she also does say in the video that, like, this is for all the times you hurt me.
Yes, it does. It does. Then again.
Yeah.
So they'd have to knock out everything else, including that I fell asleep and we were just playing and la la la.
Yeah.
They'd have to knock out all that. I'll have to. Bronco's in the middle of moving right now. I'm sure that in a month he might be in a better position to come on and talk about it. But yeah, for sure, I would definitely be wanting him on.
Not intentional. Not intentional.
Yeah. All right, let's go.
Yeah, in situations others would not. And I've tried to reach out to Mr. Brandon this weekend unsuccessfully. And my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. That's the only
on his website.
Appointment for a forensic psychologist. 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Burke. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making that she's a battered woman, we need evidence to corroborate that. So there's a lot of history between her and Mr. Torres.
Sir, there's no gum chewing in court.
Apartment complex, which is in Winter Park.
Stop chewing gum, sir.
The ownership of that apartment complex.
Bad, Zane, bad.
So it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these two, as well as we're trying to get together the 911 calls that Sarah made and others have made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports the prior domestic violence arrest of Mr. Torres, as well as the officers involved and their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other, of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these weeks.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I Can't imagine JCS may change their position with regard to those costs, since they've already said yes, but file it, and we'll try to tee it up for hearing as well to see if they have any position, or it can just be, the order can be modified to extend to you as counsel for Ms. Boone. Thank you. All right. That takes us now then to your motion for continuance file that was filed on August 30th. Courts had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Owens.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it, but it is critical to my theory, our theory of defense, battered spouse syndrome. As you know, that takes time to develop, especially the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a battered spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not involved. I don't believe you were involved at that time. I may have been.
Not me.
Okay.
My predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim. And I would respectfully ask. I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles, sometime at the end of the year, first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take a deposition. I think they may have the right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Cordelia has done a lot of the work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. They haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, San Jose County, is a little bit different. And based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense, because I don't believe my experts would be ready. And so that's instrumental in our defense.
State your position.
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several of Ms. Boone's previous attorneys. And in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would impose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice of intent to rely on battered spouse on Monday. We can't wait a week, the time is expired.
Okay, just want to say something, guys. Look, we welcome all opinions in chat. Let's not argue, hey? All right, that's all. And by now, you really should know where babies come from. I'm getting really tired of you asking.
I just wanted a third opinion.
It's about time you worked it out.
Damn it. I'll find out.
Judge that we continue today. He wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to get it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Supreme Court said 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist that makes that claim. I just can't say, hey, I'm going to rely on it. And I'm putting you on notice. I got to have some kind of authority. I'm not an expert. I think she needs the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can file that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brandon needs more time.
Oh
All right,
no.
thank you. State anything else?
No.
All right, thank you very much.
Sheriff is
Mr.
here
Owens,
and
seems
he's
like you've already started diving into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yeah.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order and judge portion, that trial specially set for October 7th, 2024, and it would not continue for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment, you undertook this assignment.
Okay.
By your own representation.
Name calling, not all right. Lynn, you're gone. Bye. Can someone please yeet Lynn Turner? Thank you. Bye-bye.
You're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020 under Mr. Padilla's representation of Ms. Boone. At no point in time
Can somebody insult me?
A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone as addressed in open court on February 9, 2024. As Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Jorge, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Jorge specializes in battered wife or battered spouse syndrome.
Don't nod your head. I know what you're looking at.
On July 17, 2023, again, by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barlow v. State, 221 Southern 3rd 562 and 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here to have the opportunity to review those. In Roberts v. State, 75 Southern 3rd 1277 and 1281, by the 4th DCA 2011, citing the Watson v. State 884.
I did giggle.
Also by the 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change in counsel occurring 2 to 3 months before the actual
Okay,
trial date.
well,
There's
so
no evidence showing that any
Dr.
Ramos'
Spiegel was
previous
timed
attorneys
out.
had provided ineffective assistance, and the defense had already moved for 4
Get it?
continuances to prepare for trial. Similar to the Ramos
Okay.
case, Ms. Boone has played a prominent role in shortening the preparation time for trial. This set forth in the court's June 28th order. The case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th. And the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial.
Did she now?
Attorney Ms. Cashman.
How?
Ms. Boone reached the point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice.
No, Judge. You don't get to just say that. You don't just get to say that Ms. Boone, what was it? What was the wording? Hang on a minute.
Administrative justice?
No. In the court's June 28th, or this case has already been continued 16 times, was specifically set for trial on October 7th for preparation for trial. When the attorney, Ms. Cashman, withdrew, notice of appearance was filed there with 37 days until not conflicted out. Hobson and Cashman, discovery has been reviewed, but with Ms. Boone by prior counsels. Ms. Boone has had the discovery in her possession since August 5th, which was, by the way, late. The court's done its own research with regard to your expertise. I have 100 cases to verdict throughout. Hang on, wait. What was the word? He said that the 16. Here we go. Continued 16 times.
16 times. As of the date of your filing your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th. And the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation.
Ms. Boone played a prominent role in shortening the time for preparation. You can't just say that and not back it up with something. Right?
What, does she have too short of a skirt too? Good Lord, blaming her.
I don't get how the judge can just say that and not say, what were the things she did to play a prominent role in shortening the time frame for this new lawyer? Right? Like, spell them out, sir. Spell those things out. Because
maybe he feels he has previously on the record, so he doesn't need to.
In his 16-page order.
That he's very proud of.
The 16-page order, which is full of malarkey.
Yeah.
Absolutely not. The 16-page order refers to the 4 attorneys who never, ever had any dealings with her, and the 4 attorneys who recused themselves because they couldn't be bothered because it's such a big case that the $15,000 that they have to split between them was not enough money to pay for their time to deal with a big case like this. And she's a bit of a pain. She's a bit of a pain. I get that. But you can't just blame it all on her. And he didn't spell out why. And come on, it's a couple more months. Big deal. It's been going on this long. Hey, God. Oh, here we go. You know this is going to piss me off. That's why you're writing it. Boone is an...
That's why David and I are friends.
Boone is a narcissist, nothing more. That does not make her mentally incapable of being found guilty. She's not a narcissist. Everyone thinks everybody's a narcissist because who speaks. If you talk too much, you're a narcissist. I don't think
you're a narcissist.
Oh yeah, I am actually. Hello, narcissist over here. Narcissist. Make way for the narcissist.
I'm clipping that.
Yeah. I'm a narcissist. He said so. Yeah.
Next time we fight, I'm using that, guys.
Don't start, David. Yeah, exactly.
Oh, God.
Free Boone. Now, there you go, Free Boone. See, I swear, this guy's got bipolar. God, here, he's got bipolar. There was someone in chat a moment ago who was diagnosing this lady as having bipolar, and she's been yeeted now because she called someone a cock throat or something. Throat cock.
Why wasn't she in my chat earlier?
I know, right? Judge is a weasel like Ted Cruz. Yeah, all right. Yeah, anyway, I don't get how he can just sit there and say that and not back it up.
I bet this guy's going to go to Cancun right before trial starts. Hell, I won't get that.
No.
Ms. Boone reached the point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Banquets, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations at various hearings, and prior counsel's motions for attorney's fees, all of which were filed among all.
That's what you say, Judge. Doesn't mean it's true. Just because you say it doesn't mean it's true.
The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you were not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15th, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida. From 2009 to 2012, you've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. And considering all the factors as set forth in terms of the state 311 sub 3rd 185 and 189, 47 DC 2020, your motion for continuance is denied. Matter of this trial is still set for October 7th. We will have pre-trial the pre-trial this matter, trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have a full practice. I've got Dr. Day this afternoon in San Luis County for Circuit Judge Scott Duncan. I've got 12 clients. Okay, I've got to be covered. I do have a full practice. If we set some of these hearings involving my motions,
What a funny day.
could I be allowed to do my
Any objection?
No, Your Honor.
The only request that I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion and provide a form order, I'll sign it and you can appear virtually. There's no reason for you to drive all the way down to Santa Rosa County for all these hearings when we can appear virtually. JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to introduce at trial. That has not happened. I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lane on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted. I don't know if they're originals, but I'm going to need to look at that. And I went to the jail yesterday. I had to let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop.
My God.
So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to look, for me to look through the digital evidence as to what they're, I assume it's being redacted. I know some of the audio in terms of clients' comments the client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State.
I'm not certain, is he asking for a continuance again? What is the extra time that he's seeking?
What is it you're asking for? Extra time to do what?
So the way I understand the order, look at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with the station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order. I'm saying I haven't had a chance to view it either.
Holy, okay, pause. What in the hell of the, what is that guy wearing? Did this
Really?
guy just go to Goodwill on his way to court and pick up some guy's suit that died a month ago?
Is that why you got me to pause?
Yeah, look at the defense attorney suit is all nice, maybe a little loose, but still pretty crisp. Nice back, everything's good. Meanwhile, this guy looks like he pulled it out of a trash bag. Now, I'm not the best dresser, I admit it. But this guy went to Goodwill to get his suit. This is just bad.
Is he the one who walked in one day in his raincoat?
Yes! Yes!
Yeah.
He also
Yeah.
got that raincoat from Goodwill.
Yeah. No, it was a decent raincoat. It was quite nice. It's just
that one fit him.
He forgot his suit.
Well, that dead guy was his size. Now, next time I'm going to court, I'm probably going to Goodwill to buy a suit. But I'm going to spend more than 10 minutes, 5 minutes, trying to make sure it fits me. And I don't look like trash bag prosecutor.
He carries it around in his car. Right?
Literally.
So
I feel like
we're talking about cacciatore. Callum's like he's been wearing it since the case started in 2020.
I feel like my cousin Vinny, and he pulls it out of a bag and just accidentally throws it on the ground in the mud. And he has to then run to the store and get a used suit.
State employees don't have big bucks to buy suits. No, that's right, Steve. It's on the
Fair, I guess. I'm sorry, Steve. I'm sorry, but
yeah. Also, Steve, what were you saying about his dad? Where is it? His dad is an excellent lawyer. I would expect his son to be as good. Are we talking about this about Owens? Hang on, I'll just go back a bit. Who was the male prosecutor? I think that is Cacciatore. Oh yeah, that's Cacciatore. Oh, are you talking about Cacciatore's dad? I don't really have a problem with Cacciatore. I think he's okay.
Yeah, I haven't seen anything objectionable.
He's not terrible. He's just doing his job.
Yeah.
As they all do. I mean, he's trying to get her for as much as he can get her for. That's what they do.
Yeah.
I have more of a problem with the judge, to be honest.
Yeah.
I feel like, and the thing with the judge is just that and this happens a lot with these big high-profile cases. He's worried about how it's going to look to the world, to obviously to the county, to the people who are going to elect him or re-elect him. He's under a lot of scrutiny. People hate this woman. They hate her so much. And if he seems to be given any latitude whatsoever to her, then he is just not doing a good job. But then again, he has to be impartial and fair and all that kind of thing. It was a really hard situation that he's in. But then there's this situation where there's a budget for the public defenders, a $15,000 flat fee, and then they keep leaving. They don't want to work with her, or they just don't want to work on such a big case with voluminous discovery, lots of videos and depositions and things, and they're running out of budget to do their work. And it just goes on and on and on for 4 years, and people are like, hurry up, get it done. And now we're at this situation where we've got this lawyer who's sort of flown in from the north and gone, I'll save her. And he wants a continuance, and he really deserves a continuance. I mean, come on. He's got, 3-4 weeks till trial, and why should he not get a continuance when every other lawyer who's represented her has had a continuance? But then in front of the public, it looks terrible to give a continuance because they're all like, well, you said no more continuances. There's been 16 continuances. But is that an appellate issue now to not allow continuance to a brand new lawyer walking in off the street who's there to ensure she gets a fair trial? I don't know. I don't know how you can argue that that's fair to not give him time to prepare. cracks, no defense. You say to her, she needs to plead and try for mitigation, and she will not listen. So they quit.
So they quit.
So they quit.
What do you think would be a normal plea offer for her in this situation? Because she's already served almost 5 years. So, I mean, how much more would she spend in prison? Just my thought.
Interesting. Also, I read you went to law school with Cacciatore. Which is weird because it was in Chicago and it was not this guy. Oh, a Cacciatore. How many lawyer Cacciatores can there be? Well, I know of a chicken Cacciatore. Yeah. Anyway, let's go. So yeah, just when you can return the chat, that'd be cool. So thank you for your input.
On August 9th, Mr. Owens, we had a different hearing. And in that hearing, we addressed the digital discovery review. Mr. Lane was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, present date break investigations. By through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state's digital evidence, tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall file a report and notice reflecting that the discovery of the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail according to the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m. a hearing will be held, courtroom 12A, regarding defendant's review of the USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024, the pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which said the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay, state?
No.
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to admit into evidence and tender any objections?
I've got to go by jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue, maybe a week prior to trial, whatever that is, a week prior to that Monday, October the 7th, the week prior.
State?
I'm going to be amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Attorney Owens?
1 minute.
Sure. State anything else?
Not this time.
Madam Clerk, going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. First time no business before the court, you'll have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
He's like, yeah, that didn't go very well. And she's like, yeah, you can do it in 3 weeks, right? That's like, sounds like my graphic design clients. They're like, yeah, don't worry. I'm sure you can pull it together in 3 weeks. It's not too bad.
Oh, hey, or my clients. Oh, hey, I have an emergency order for a building that's going to be inspected in 2 weeks. Can you go ahead and give me these 300 signs done? No. I really can't, sweetie. No.
Yeah, no problem. No problem. Hang on, let's just look. Did you go back over there? No. Oh, you have to get that pen back. You might stab yourself or me. Yes. All right. Well, I'm annoyed. I'm pretty annoyed. But as Steve said, what's this? I'll read Steve's last one. Because I said, Steve, it could be argued that the defendant didn't actually cause the delays, as the court has stated. If that's the case, is this a potential appellate issue? And he's gone, an appellate lawyer will raise it, but I suspect it will be unsuccessful. What is it? Something like 4% of appeals are successful, 4 to 7%, something like that. So, yeah. It drives me down forever. You know you're stuck with that for 2 weeks, right? Hang on. Oh, is that you? Is that actually? That's not you. Yeah, no, that's not her.
That's David.
Come on.
It's David.
David. It's a shame some of your mods think they have the authority to condescend your viewers just because they are a volunteer mod. Dear. There's so much shenanigans going on in chat today, whatever it is. If a mod is rude, man, you can do the voice.
If a mod is rude to me, I will not back down. I'll create 50 channels. Okay, Juju. I'm not mad at you.
Oh, hello, Melissa. I can't even tell you what's going on. Are you sure it's David or is it that woman?
Pretty sure.
Okay. All right, hang on. Stick with me. We're gonna raid potentially criminal. What's he doing? Oh, is he live? Oh yeah, he is live.
Not with that attitude.
Yeah, he's live. Why not? He doesn't really need a raid. Maybe we should. Maybe we should raid publicly buzzed instead. He'd probably appreciate it. Yeah, that'd be good. Let's do that. I mean, we love both of them, but I think you guys can go wherever you like once we do the raid. But let's do that. Let's do that for him. So, I'm just doing what I have to do. 2 seconds, guys. All right. So before we leave, I just want to say one thing, and that is tomorrow at 8:30 p.m. Eastern, we have something really important happening. If you don't like cancel culture, and I know there are a lot of people who don't like cancel culture, I am big time against cancel culture. I'm big time against haters.
Haters gonna hate.
Yeah, and there are some big haters in the whole world of Murdoch. And I'm talking Alex Murdoch now. Tomorrow at 8:30 p.m. Eastern, this is what's happening. I will be sharing with you or inviting on my friend, my really good friend. I'm going to just share this tab.
Golly.
Crime and Cask. No, not you. Oh. Well, you're welcome, but sure. Crime and Cask. Now, Crime and Cask, here he is. There he is. Crime and Cask. He is the author of the best-selling new book, Juror 785, Because Enough is Enough. She was known as the egg juror on the Murdoch panel or Murdoch jury. She was struck from the jury just before they went into deliberation because apparently she was the one who was going to vote not guilty. And when Judge Newman said, would you like to pick up anything from the jury room? She said, my purse and a dozen eggs. So that's how she became known as the egg juror. Her name is actually Myra Crosby. And she's been speaking on Fox Nation, on Fitz News, on a lot of different channels recently. Now, unfortunately, some people are very angry that Crime and Cask has written this book and expose this information. And they have gone and doxed him. They have brought out some ridiculous claims against him. And I am going to bring him on my channel and give him the opportunity to speak out about the lies that these people have been speaking of him. There are just some just egregious things that people have been saying about him. And I could do a stream similar to the one I did about Steve, where I just research it and present it myself. But he wants to come on and talk about it. So I absolutely, that's what he would like to do. He's more than welcome. So he's coming on at 8:30 p.m. tomorrow, and he's going to address this stuff himself. Thank you, Dali, for the 2 gifted memberships.
Oh, you're welcome.
Much. One there and one there. So, guys, please, if you agree with free speech, if you agree with people's right to do their own journalism, to go ahead and investigate and put forth their theories as to what's happened and publish it, and then not to be attacked by people who don't agree with justice playing out the way that it should, please come on and support him tomorrow. This is very brave of him. He'll be on my channel 8:30 p.m. tomorrow Eastern. And there's another one there, 3. And what, 4? 4?
Maybe.
Goodness me. 4 excited utterance memberships. Thank you so much. Author of Better Books, Juror 785, Because Enough is Enough, Crime and Cast, claps back at Vicious Lies, exclusive tomorrow. Yes. And 5. You know there's a little button you can click to hit 5.
I like to be obnoxious and just do it like one at a time.
My mod attacked an innocent viewer. Oh, really? Okay. Hello, Lawless. My mod didn't attack anybody. No, that's not true. And welcome to the channel. How are you? Nice to see you.
Why can't I ever get these fun people visiting my channel?
I know, right? I've got all this excellent stuff going on. Well, darling. Okay. All right. Anyway, we are going to go and
oh shit, Half Irish. Thank you so much. Okay, I boomered.
Did you? Righto.
Oh my god.
So what?
I'm a retard.
You've been on your channel this entire time? Doing what? You didn't end your stream?
What?
What did you not end your stream?
No, I did. I just did the wrong time.
Oh, okay.
I forgot to set it up for tomorrow.
Stop yelling. Okay. Anyway, that's tomorrow, 8:30 p.m. Eastern. Please join me for that. It's gonna be spicy. He's gonna get mad, I think. I don't know what Dali's upset about, but he can have a little drama attack in a minute. Let's go raid Publicly Buzzed, and I'll see you either there or over at Sean's afterwards. But everyone say hello raid when you get there. It will be fun. And I'll see you also tomorrow for Crime and Cast Claps Back. Because enough is enough. Because enough is enough. Alrighty, time for the music. Everyone, time for the music. Ready?
Her name was Ella. She was an Aussie. She was a fake lawyer from the future. She got on YouTube and made some live streams. The co-host is Donnie and she dances sometimes. The words are always so loud and because she's an 803.
Oh, Junior's a real Nazi right now.
Her cat is staring through when he goes missing. We are censoring.
Yeah. Uh-oh.